Disputes related to patents in WTO. As a part of week 4 discussion, we are going to really understand that what type of disputes countries are having today in the World Trade Organization. And as we know that these disputes have a different meaning in WTO. So, this particular presentation is divided in 3 parts. In first part, we are going to have the idea about the meaning of disputes in WTO. Then particularly on the patents related disputes, in this lecture we are going to really see that what type of disputes among the countries are going on, which is related to the patents, and how dispute settlement body is trying to resolve certain disputes today, and what type of countries reactions are also available. And there are different articles in the trade related intellectual property rights, and countries are really complaining against other country for the violation of those intellectual property rights, and then we will try to have the conclusion on the cases related to patents in the dispute settlement body. So, the general meaning of dispute in WTO is a condition or a dispute is a case when any WTO member violates any agreement or commitment that it had made in the WTO. So, the disputes are not among the firms at WTO level, but disputes are at the level of two country or two party, and sometime if the dispute is if certain disputes are highlighted by a party against some other party, then when a party is finally complaining against another country, then there are third party involvement also, and some other countries are also supporting the complainant to finally put certain violation of articles of trade related intellectual property rights. So, for the settlement of disputes, a dispute settlement body has been also made, and dispute may be of patent infringement, may be of copyright, may be of trademark, may be of license, may be of domain name, and varieties of disputes we are finding today in the dispute settlement body. And there are 31 cases, and I am also providing a link to understand the entire disputes available in WTO, especially related to intellectual property right, and that link is giving you the broad range cases and ideas about what type of disputes are available today. Some of the disputes we are going to highlight today, we are going to discuss today, maybe in the field of patent or maybe in the field of other intellectual property rights. But you can must have the reading of these disputes available on the WTO website, and for that the link is also being provided to you. So, you will find out, and apart from that, it is also important to read the different articles of trade related intellectual property rights, the TRIPS. So, all these discussions and disputes, all these cases are going to give you a wide range of ideas that how intellectual property rights today is one of a very sensitive and controversial issue, and country do not want to really compromise on these intellectual property right issue. So, this from this particular table you can just have a look that number of cases related to patents are 11, and there are different cases has different numbers, and DS is basically for the disputes, and different numbers are assigned to different cases, and we are finding that 11 cases are related to disputes in WTO, which is mainly related to the patents. Like patents, we have large number of again disputes related to copyright and related rights, and almost 10 cases we are finding in this part also. And the third position related to disputes are on trademarks, and we are finding 9 cases related to trademarks. We have 4 cases related to geographical indications and one case related to undisclosed information, and there are overlapping of the cases also. Some of the cases are also the cases related to trademark, also cases related to geographical indication. So, from this table we can see that large number of cases are continuously available today, and some of the cases which we are going to discuss today is the disputes related to disputes between Pakistan and United States for the patent protection of pharmaceutical and agriculture chemical products, disputes related to Portugal and United States, patent protection under the Industrial Property Act, DS 50, which is the dispute related to India and United States, again which is related to the patent protection of pharmaceutical and agriculture chemical products. Again, European communities and India disputes related to patent protection for pharmaceutical and agriculture chemical products. The disputes related to between the Canada and European communities, which is again related to patent protection for pharmaceutical products. And apart from these discussions, we have the disputes between the European communities and Canada for the pharmaceutical and agriculture chemical products, Canada and United States terms of patent protection, Argentina and United States pharmaceutical and test data protection of agriculture chemicals, again Argentina and United States certain measures on the protection of patents and test data, again Brazil and United States measures affecting patent protection, and United States and Brazil US Patents Code. So, let me briefly discuss some of the cases here. The case between the Pakistan and United States, as we said that this is the violation of Article 27, Article 65 and 70. The issue is basically related to a system for patent protection for pharmaceutical and agriculture chemical products and executive market rights, and Pakistan and United States has mutually agreed for protecting the articles of 27, 65 and 70 a long time back in 1997. The case of United States and Portugal, Portugal complained the United States for providing TRIPS agreement, for violating TRIPS agreement article 33, 65 and 70, and its Industrial Property Act matter was again mutually agreed on 3rd October 1996. Again in case of India, the US complained against India for alleged absence of patent protection for pharmaceutical and agriculture chemicals and which has again violated article 27, 65 and 70. In case of disputes related to European Commission and India, this particular European Union complaint was against India for violating article 27, 65, 70, 70.8, 70.9, which shows the absence of patent protection for pharmaceutical and agriculture chemical products and absence of formal system that permits the filing of patent applications of and provide executive marketing rights for such products. So, US was also the third party in this case. On 25th November 1998, India agreed the required agreement. The disputes related to Canada and European communities, the European communities complained against Canada for violation of the patent protection of pharmaceutical products, and Canada had violated article 27, 27.8, 28 and 33 of TRIPS agreement. And it is better to read all these articles in detail. We are going to provide you the link of these articles, and these articles are the articles which is the binding articles of different countries to follow the trade related intellectual property rights, not only in a very selected countries, but in the large number of countries which are the member of the WTO. So, all these articles are the articles which has to be followed by most of the countries, and wherever there are certain flexibilities and waivers are provided, that has been provided on a certain ground, and that ground should not be really violated in any case. So, the case of DS 153, which is the case between the Canada and European Union. Canada complained against European Commission for violating of the TRIPS Act 27.1 in respect of the protection of invention in the areas of pharmaceutical and agriculture chemical products. The case of DS 170 between United States and Canada, US alleged that under Canadian Patent Act, the term granted to patent issued on the basis of application filed before 1st October 1989 is 17 years from the date on which the patent is issued, which should be 20 years and is consistent with the TRIPS article 33, 65, 70. On July 2001, Canada informed the dispute settlement body that it had fully complied with the regulation. The case which is DS 171 between the United States and Argentina, the US complained against Argentina for the absence of patent protection for pharmaceutical products. US contended that TRIPS agreement does not permit WTO members to allow third parties to market products subject to exclusive market rights without consent of the right holder. According to United States, Argentina's law does not provide product patent protection for pharmaceutical inventions or a system that conforms to Article 70.9 of TRIPS agreement, which regard to the grant of exclusive marketing rights, but the dispute was again mutually agreed on May 2002. So, this particular case DS 196, which is between the United States and Argentina. In this case, the US again complained against Argentina that Argentina failed to protect against unfair commercial use of undisclosed tests for market approval of pharmaceutical or agricultural chemicals, which prevents chemical products, preventing the infringement of patent rights for occurring. The measures were inconsistent with Argentina's obligation under TRIPS agreement, including Article 27, 28, Article 31, Article 34, Article 39, Article 50, Article 62, Article 65 and Article 70 of the agreement. So, I have the copy of this entire document of the different entire document of the different articles of TRIPS agreement. So, one must you can either download or you can read it online, and these articles are interconnected and it has more interdependency. When a case is filed, the countries are basically trying to expose the other party that what type of violations are being made and what are the articles were violated. Sometime Article 27, some paragraph, Article 27.1 means first paragraph, Article 27.2 means second paragraph, and so it means that certain articles, certain paragraph of certain articles which has to be cited as the violation of the articles must be in consideration for the countries to acknowledge. And we find here that countries are really smart enough to expose other country that on which ground your cases is the cases in the dispute settlement body. So, in this particular case the DS 196 between United States and Argentina, when Argentina has responded, this is the one case where we are finding a large number of violation of articles which is 27, 28, 31, 34, 39, 50, 62, 65 and 70. So, for example, Article 27, if one has to see the Article 27, which includes what type of members may be excluded, for the members may also be excluded from the patentability, the inventions, the preventions within the territory of the commercial exploitation of which is necessary to protect different type of protections, including the protecting human, animal, plant life and health, or to avoid serious prejudice to the environment. So, different items are already cited here, and countries are trying to highlight these articles to make their case more strong, so that respondent has to react and respond accordingly. So, the case related to DS 199 between United States and Brazil. In this particular case, United States complained against Brazil for measures affecting patent protection. The US claimed that the measures were inconsistent with the Brazil's obligations under Article 27 and 28 of TRIPS agreement and the Article 3rd of GATT 1994. The Cuba, the Dominican Republic and India, Japan, Honduras, also they were the third party in this particular case. The dispute was mutually agreed and it went to the final solution on 5th July 2001. So, one more case which we must discuss is the case related to Brazil and United States, where the United States was the respondent and Brazil was the complainant. So, Brazil complained against United States for provisions of the US Patent Code. Brazil detected several discriminatory elements in the US Patent Code. The measures which were violated are Article 27 and 28, the TRIPS agreement and Article 2 in particular, and Article 3 and 6 of the GATT 1994. So, if you want to see the different articles of GATT 1994, General Agreement on Tariff and Trade, which was the last round of the General Agreement on Tariff and Trade, I can also provide you the link to read some of the articles of the General Agreement on Tariff and Trade. Also the TRIMS agreement, Trade Related Investment Measures Agreement, which was also the part of certain violations, you can also have a look. But the fact is, when we are having the discussion on intellectual property rights and the violation of patent rights, you can really find out the articles which is linked with different articles related to TRIPS, and this is a small document which includes different articles of TRIPS agreement, that is around 33 pages. You can find out that this is really important to understand these cases, because certain articles are cited. So, if you will have the idea about these articles, you will be able to really link that what type of violation countries are having against products from other country. And so, this exercise gives you the idea that how dynamic these countries are to fight against their rights, their obligations in WTO. So, to conclude, most of these cases have been registered by developed countries, and many of them are from pharmaceutical product side. And majority of the cases which we have seen here is basically the violation of Article 27, Article 26, Article 28, Article 29, Article 65, Article 70 and Article 33. So, all these articles are basically the guiding principles that what should be patented, what should not be patented, and what type of relaxations and flexibilities are available for the countries. And it can be summarized that in many of these cases countries are able to resolve, but in some cases these articles of TRIPS looks more complex and challenging for developing world. So, the entire discussion on intellectual property right and the economics of intellectual property right is beyond the boundary of the nation today, and the violation of these articles are not in the control of one country, but the other countries are equally prompt, active and dynamic to tell the violators to the country who are not really able to comply the articles of these agreements, which is already signed by the country. Other third parties are also involved in taking proper steps and precautions, and they are really providing lessons to any country who violates these agreements. So, we find that it is not the old world where we live today, it is the new world where all these countries, smaller countries, bigger countries, developed countries, developing countries, all these countries are really active to control the infringement or to control the violation of these articles, and dispute settlement bodies are very much active to take proper action, to find out the solution, to give a platform to resolve the disputes. And due to the dispute settlement body, some of the countries are in the position to resolve these disputes, and for resolving these disputes, after resolving these disputes, it is not only the two party who were involved in disputes, they are only getting benefits, but other third party who are not involved in the disputes, they are also getting the equal benefits, because the entire TRIPS agreement or the entire intellectual property rights at the global level works on two basic principles, and that is MFN and the most favored nation principles. And we find that all these articles where there is a violation, where there is a favoritism, where there is a incompatibility, where there is a problem of compatibility, we are finding that all these different countries are very much active to control such activities, and this shows that we are having a global system of intellectual property rights and global system of regulation of intellectual property rights, and a system of globally recognized system of settling the disputes, that is dispute settlement body. Thank you.